Um, Hello, sir. Welcome, sir. Guys, we will be starting in a minute. Before that, let me introduce you all to our today's expert. Good evening, everyone. Please join me in welcoming Mr. Jeevan Ballabh Panda, a distinguished partner at Khaitan and Company, one of India's foremost law firms. With more than 16 years of expertise in resolving complex disputes, Mr. Panda has developed a robust practice specializing in commercial litigation, arbitration, and employment law. His contribution extend beyond courtroom advocacy to include significant roles as an arbitrator at both the Indian International Arbitration Center and the Delhi International Arbitration Center, where he has imparted fairness and strategic insight in numerous cases. Over the years, Mr. Panda's professional excellence has earned his numerous accolades. He is celebrated in prestigious legal rankings such as the Indian Business Law Journal, A-List, and Benchmark Litigation Asia Pacific's Top 40 Under 40. Moreover, his consistent recognition by esteemed directors like the Legal 500 and Asian Legal Business underscores his status as a leading voice in the legal field. Today, he is here to share his experience and insights on the topic of commencement of arbitration, offering invaluable guidance drawn from years of practice at the highest level of legal excellence. So over to you, sir. Please continue.
Thank you so much, Akarshvi, for the kind introduction, and thank you, LawSikho, for giving me this opportunity and the platform to express myself. Uh, Today, we'll be discussing the topic commencement of arbitration, which is something which is very significant at the very nascent stage of arbitration proceeding and is critical and in shaping the entire life cycle of the arbitration process. It's somewhat kind of the foundation which is laid down before you start the superstructure being built upon it. So therefore, the foundation, as you know, is extremely important when you're talking about any superstructure being built. So therefore, we'll be discussing this topic in a bit detail. And before moving on to the topic, I would just give a brief introduction about like generally why arbitration, why are we having this conversation at the first place. So as you know, we always had alternative dispute resolution mechanism as part of Section 89 CPC, and the Arbitration Act itself, like 1940 Act was there. Then we had the 1996 Act, which was the new act as per the UNCITRAL model laws. Thereafter, we have seen significant judicial pronouncements, particularly after the 1996 Act, and more so after the 2015 amendment and the 2019 amendment. You see, there are a lot of judgments where the courts have taken a very proactive role in terms of taking an approach which is pro arbitration and reduce judicial intervention. Now, the terms like reduce judicial intervention and like efficiency, effectiveness, etc. These are some of the key words.
Uh, So we are not able to hear you. I guess there is some network issue at your end. Uh, Class, I think there's some network issue at Sir's end. He will be joining us again, I guess. Sir, I guess you're on mute. We can't hear you. Uh, there is some network issue at Sir's end, so let's wait for a few minutes.
Akashvi, am I audible now? I'm sorry, extremely sorry.
Yes,
There was some issue with my network. Yeah. So if I may just share the screen, Akashvi, if you can just
yes, sir.
allow me to
Sure.
share screen. Yeah.
Done, sir.
Is it visible?
Yes, sir.
Okay, thank you. So sorry, just to continue where I left, what I wanted to highlight is that why at all we are having this conversation about arbitration, why arbitration has become suddenly so important. So the reason why it has become important is because we have tardy and cumbersome procedures associated with our courts. We have overburdened courts where the justice dispensation is extremely slow. And of course, there are other incidental issues that we come across, like lack of the number of judges for in various courts, including the high courts and the Supreme Court, which has resulted in a shift towards alternative dispute resolution mechanism. So what I was trying to emphasize is that the aspect of alternative dispute resolution was always there, and it finds mention in the section in section 89 of the CPC. But when you talk about practice, it took us several decades for arbitration itself to be accepted as an effective mode of dispute resolution and accepted in our mainstream dispute resolution mechanism. When you talk about conciliation, mediation, etc., we talk about it a lot when we are speaking in conferences and seminars, but the acceptability will take some time in the same manner that we had arbitration had to it took several years for it to get some form of acceptability that we see today. Even after the 1996 Act, if you see the judgments of the Supreme Court and High Courts, particularly in the initial part of 2000 and 2010 until 2015 rather, every stage, every provision of the Arbitration and Conciliation Act you saw, there was judicial interference, and the scope of interference was significant when it comes to each of those provisions. Now, if we talk about the entire scheme of the Arbitration and Conciliation Act, it essentially talks about three phases. The first phase, which is essentially the pre-reference stage, where you have provisions like Section 9 for interim measures of protection. You have Section 11, which we will be discussing it in better detail today, which talks about appointment of arbitrator through the court. And you talk about Section 8, when the court has power to refer parties to arbitration. Similarly, there is a reference stage where the arbitrator enters into the reference, or the arbitral tribunal is constituted and they enter into the reference. And thereafter, you have various provisions like Section 12 read with 13, 14, Section 16, which is based on the principle of competence, and the power of the arbitrators to determine its own jurisdiction. Similarly, post-award stage, where once the arbitral award has already been passed, there are provisions like Section 34, where you get an opportunity to challenge the arbitral award if you are aggrieved by it. Similarly, you have the other provisions, like even Section 9 can be invoked post-arbitral award when you have a good case to secure by way of an interim relief, even prior to the execution of the arbitral award. You can file a Section 9 if the judgment debtor is in a precarious financial position, etc. So the objective behind highlighting all these provisions is that at each stage you saw there was judicial interference which was taking place, which made the entire process of arbitration essentially nugatory and meaningless. Because if the courts ultimately have to spend considerable time in adjudicating the incidental issues associated with arbitration or the technical issues associated with arbitration, the question of arbitration substituting mainstream traditional form of court litigation would not arise. It would not let like unscrupulous litigants who are deliberately resorting to such vexatious litigation, like filing applications one after the other, challenging the jurisdiction of the arbitrator, or filing a Section 9, getting an interim relief with no actual intent to invoke arbitration, then the very purpose of arbitration as a process would stand defeated. That's exactly what used to happen. And as a consequence of that, litigants and lawyers alike, they used to treat arbitration as a just tick in the box, and was never considered or taken very seriously. I'll give you an example from my own experience. When I started my practice in the year 2008, uh, when I attended arbitration proceeding, one observation which I had was that all the arbitrators were fixing arbitral proceedings post court hours, effectively 5 to 7 or 5 to 8 p.m. or 4:30 to 6:30. Like the schedule used to be such. And generally, the lawyers and the arbitrators were also reluctant in spoiling their weekends or fix arbitration proceedings during weekends. So effectively, the 2 or 3 hour session, the effective arbitration used to go on for not more than half an hour. Now, the obvious question would be that what would they do in the remaining time period of 1.5 hours or 2.5 hours, whatever the case may be. So as a young practitioner, what I used to observe was that a mockery of the entire process, and all at the client's expense, at a five-star hotel or a like posh club in the city, where there was a lavish spread of high tea menu, and all pre-decided. And as the solicitor, we used to get calls even from the arbitrators beforehand that there should be sufficient food for them to consume there, and also pack it for their grandchildren. So that was the and specific menu. For the menu, there were specific items which were dictated, and so that those were ordered in advance without fail. So of course, you as a solicitor, as a client representing the client, you would not like to antagonize the tribunal who is there to decide your client's interest, their rights in a commercial matter, which usually were high stake. So as a young practitioner, I always used to question then what is the benefit which the client is getting out of it, and the client's officials, the in-house counsel essentially, or the business team members used to witness this mockery happening at their own expenses in the presence of a hall full of people. Enjoying and merrymaking for majority 90-95% of the time, which is essentially fixed for adjudicating disputes, and it was supposed to be a serious business. But effectively, for the remaining time, whatever was left, that you the arbitrators, who were mostly retired judges of the High Court or the Supreme Court, they used to spend time on like talking about they also used to spend time about discussing about what's the talk of the town, or what is the political scenario, or the what is being discussed in the High Court corridors or the Supreme Court corridors. So essentially, as a young practitioner, it never instilled confidence in my mind. So you can imagine what confidence it would instill in the mind of the lawyers or the litigants who are actually spending significant amount of money for these arbitration process. Now, like I always thought that litigation was much better then. There is no question of having, if ultimately we have to go back to the courts, and the courts, while adjudicating an arbitral award challenge under Section 34, they used to effectively decide it in the form of an appeal. And if you, even today, there is a common myth that there is an appeal against an arbitral award, which is not the case. If you see the provision, the language is challenge to an arbitral award. It is not an appeal, typical appeal as it is understood under the Civil Procedure Code. It is not the case. And as you know, the provisions provide for very limited grounds of challenge. Of course, with each passing amendment, it has been narrowed down. The scope has been narrowed down with each passing amendment. And the objective is quite clear, that it is in line with the objective of reduced judicial intervention. And if you see any successful like jurisdiction, be it Singapore, UK, etc., the touchstone of success of any jurisdiction to be an arbitration-friendly jurisdiction, it lies on the fundamental principle of reduced judicial intervention. The moment there is intervention, it's not going to work out. So now what has changed suddenly? So my personal reading of the situation is what has changed from 2008 till what we see arbitration today is that the 2015, which I say as the game-changing year when it comes to arbitration jurisprudence. Now, why I say so is because of the fact that insofar as arbitration proceedings are concerned, there are significant changes which were brought in and which were much required to bring in some form of discipline into the process. First and foremost, like if I may just list down 2 or 3 out of them, first and foremost is that no automatic stay when it comes to challenge to an arbitral award. Earlier, the practice used to be unscrupulous judgment debtors. They used to file a Section 34 within the timeline stipulated. That's all that they did. And the moment there was a stay on the execution process, there was no requirement for any deposit or any condition being imposed. And that used to languish in the courts for years together. And the award holder used to suffer. That again acted against the spirit of the arbitration process, and again discouraged litigants, saying that if the judgment debtor is happily sitting over a challenge to an arbitral award for years together, what fun did I get out of participating in an arbitration proceeding which lasted for say 4 years, 5 years, with so many sittings and so much of expenses? I was better off maybe paying off the court fee in a court and filed a civil suit then. So that is one of the game-changing event, I would say. Section 34, there is no automatic stay and there is mandatory condition of deposit. My experience has been that courts do not hesitate in appropriate cases in directing deposit of the entire 100%, or if not 100%, 50 to 75% of the awarded sum, which the award holder these days can withdraw by furnishing some form of security, say a bank guarantee or indemnity, etc. The second important change is about the aspect of fourth schedule being introduced, which brings about a guideline as regards the cost associated with it. The cost associated with an arbitration directly proportional to the sum in dispute. Earlier, it used to be that it used to be considered as a pension plan for retired people, and the arbitrators used to make more money in the process, more than what they used to make when they were in service. And I'm conscious of the fact that like majority of the arbitrators used to be retired judges of the courts. And so therefore, this is another significant development. And the third most significant development, the third most significant development, I would say, is the amendment to Section 12, read with the fifth, sixth, and the seventh schedule. Here, it is directly related to our topic, and that is the reason I'm emphasizing this, is because it talks about an independent and impartial arbitral tribunal, which is important for instilling confidence in the mind of the litigants, because it is serious business. And when arbitrators are appointed or a tribunal is constituted, they are essentially substituting the role of judges in courts. So therefore, as we say that with great power comes great responsibility. So when the powers are being entrusted with each passing amendment or with each provision, empowering the arbitrators and reducing judicial intervention, so the role of arbitrators assumes significance. So appointing an independent, impartial, unbiased arbitral tribunal is key, because if you have integrity issues with an arbitral tribunal, then it would again be detrimental or prejudicial to the institution itself, the institution of arbitration itself. So these were some preliminary thoughts I wanted to give. And of course, like with the silver lining of the entire COVID pandemic was that we were all adopting and adapting technology. And rather, we were not left with any option but to accept and get used to it. We were left with no option. So what I'm trying to say is that it increased the efficiency. It gave us the exposure to use virtual hearings in not only in courts but also in arbitration. We have from my own experience, I can tell you some of the arbitrators were extremely reluctant, and they actually kept the entire arbitration process in abeyance during the pandemic, and only when the lockdowns were lifted, they were insisting on what you call having arbitration proceedings physically. And the other kind of arbitrators that we actually worked with, they were having actually standard orders which they directed, which they passed and insisted as a part of the procedural order, that starting from the procedural hearing till the final arguments, they had laid down the entire process. For example, in case of witness action, they had directed that if I'm the claimant and the respondent's witness is getting cross-examined, I had the liberty of deputing one of my colleagues to attend the respondent's office, where there will be one laptop to which the screen will be facing. The witness will be facing the screen, and there will be one more laptop behind, which would basically show him the witness from behind, so as to ensure that there is no device, there is nobody else in the room, and nobody is prompting. So to ensure fairness, the arbitrators had given this direction, and it was completely smooth, seamless, and we were able to get entire proceedings disposed of in like 5 months, 6 months, and in some cases even earlier, where there was no evidence. So that was a positive use of technology. At the same time, I'm also conscious of the fact that when it comes to heavy volume arbitration, or say, for example, if it is a EPC contract with say 50 volumes of documents, and it becomes slightly more convenient if you have physical hearings. So when arbitrators have assumed such a significant role, the initial part of the arbitration process, where you are actually constituting the arbitral tribunal, assumes significance. And that is the reason this commencement of arbitration is extremely important, because what is the constitution of the arbitral tribunal? Who are the members of the arbitral tribunal? It's extremely key. And we'll be discussing what are the various factors one needs to consider while appointing an arbitrator, and how we say that it amounts to a commencement of arbitration. Now, with this background, if I just move forward. So broadly, these are the topics I'll be covering in course of our discussion today. Invocation of arbitration under Section 21, which is basically pari materia with that of commencement of arbitration. Second is we'll be discussing what are the various ingredients of the notice invoking arbitration. I'll be taking you through, according to me, like what are the basic ingredients which one must consider incorporating while issuing a notice invoking arbitration. Third is the selection and appointment of arbitrators, which I was mentioning just some time back, as to why it is critical when it comes to appointing a good, a fair, independent, unbiased, and impartial arbitral tribunal. And the last is our rights and duties of arbitrators. I'll just briefly touch upon. We'll not be doing a page turn of it, but at the same time, I'll just be briefly touching upon what are the broad rights and duties associated with arbitrators. So, setting the arbitration machinery in motion. And as I said, this is the very first and one of the most significant steps when it comes to the arbitration proceeding, where you lay down the foundation of the arbitration process. Now, it finds its roots in Section 21 of the Arbitration and Conciliation Act. And as I said, that invocation of arbitration is essentially what is meant under the head commencement of arbitral proceeding. And if you see the language, it starts with the phrase, unless otherwise agreed by the parties. Now, this phrase one must be very familiar with when you are talking about the entire framework of Arbitration and Conciliation Act. Because it is found in many other provisions of the statute, and the objective of having this provision preceding any provision of various provisions of the Arbitration Act is because it emphasizes the aspect of party autonomy, which is sacrosanct when it comes to arbitration as contradistinguished from litigation. So here the parties are the boss. They decide what they want to and how they want to have their disputes adjudicated, what is the process, what is the procedure that they want to follow. And that entire independence has been provided for as part of the arbitral process. So therefore, anything and everything has to be subject to any agreement between the parties. So therefore, the words unless otherwise agreed by the parties. In other words, if the parties have not agreed to some process or the procedure, then only the provision kicks in. Otherwise, if the parties have agreed to something under the arbitration agreement, then that would prevail over and above the provisions of the Arbitration and Conciliation Act, and particularly when we are talking about Section 21. So going forward, as I said, it is also commonly known as the invocation of arbitration or notice invoking arbitration. Second is, as I said, if the parties have agreed to a commencement date under their agreement, say, for example, if the parties say that at a particular stage, the date of appointment of arbitrator, the sole arbitrator, or the constitution of the arbitral tribunal, or the date when they actually hold the first sitting should be considered as the date of commencement of arbitral proceeding. If the parties have agreed to such a provision in their contract, then that would prevail. Otherwise, the principle behind Section 21 is that when the notice invoking arbitration has been issued by the claimant and delivered to and received by the respondent, that's when it is deemed to have commenced for the purposes of Section 21. Now, the date of commencement is extremely important because it determines the limitation for lodging of a claim by the claimant. Second, it is also important to decide on what is the limitation period for filing your application for appointment of arbitrator under Section 11. And of course, the raising of a substantive claim, whether it is a stale claim, whether it is a whether it is claim which is barred by limitation or not, all those aspects can be determined by keeping the date of commencement of arbitration proceeding as the benchmark or the base date. Now, moving on, these are the relevant considerations which are extremely important for one to consider before invoking arbitration or before the commencement of arbitration process. First and foremost is that there has to be an existence of a valid arbitration agreement. Now we talk about all these Vidya Drolia principle, etc., when it comes to arbitrability of disputes. So first and foremost, there has to be an arbitration agreement which is to be in place, which should cover the subject matter of dispute. There may be a situation where you may have an arbitration clause, but at the same time, the arbitration clause is not wide enough to cover the subject matter of dispute, which you are seeking to have it adjudicated in the arbitration process. Just give me a sec. So the existence of a valid arbitration agreement, when we're talking about, the arbitration clause should be broad enough to include the subject matter of dispute. Now, generally, you see the very widely worded clauses like any dispute or differences arising out of or in connection with so and so. So that is as wide as it gets, and it's a very wide provision which would possibly include anything and everything and any kind of dispute which can be contemplated under the arbitration agreement. Having said that, if a party intends to refer a kind of dispute which inherently is not arbitrable, for example, an issue involving operation and mismanagement, which is not arbitrable as per the laws of India. And of course, the Vidya Drolia principles reiterate the various categories of non-arbitrable disputes. So if a party is intending to have those kind of disputes arbitrated and invokes the arbitration clause for adjudicating such disputes, then of course no arbitrator can be appointed and the dispute cannot be adjudicated by way of arbitration, and it has to be nipped in the bud at some stage. Secondly, there has to be an existence of a dispute for reference. So many a times it happens that there is only a disconnect or difference of opinion between the parties, and it has not culminated or it has not fructified into or matured into a dispute as yet. But still, a party invokes arbitration. Another example I would give is that if the parties have some disconnect as regards a particular date by when a goods are to be delivered, or say services are to be rendered, or say a particular delivery is to be made, but there are some correspondences which are being exchanged. But technically, there is no claim or no dispute which has arisen as a result of this disconnect. In that scenario, a party cannot just invoke the arbitration and proceed to refer parties to arbitration or apply for referring parties to arbitration. In that situation, again, it would be a premature invocation. And many a times we have seen that the courts, while exercising powers under Section 11, they refuse to appoint an arbitral tribunal by directing the parties to exhaust their recourses, including the fact that let the disconnect or let the issue in hand mature into a dispute for it to be referred to arbitration. So therefore, one must be mindful whether it is only a divergence of views or whether it has actually culminated into a dispute for the purposes of the invocation as per the provisions of the arbitration agreement, which has been agreed between the parties. Third is, as I was mentioning at the beginning, that there are these days you see various commercial contracts where the arbitration invocation itself is it's preceded by various other alternative modes of dispute resolution, for example, mediation, conciliation, negotiation, etc. So only after you exhaust those alternative dispute resolution mechanisms that you can actually formally invoke arbitration. But parties go in a rush they say that nothing doing, I'm going to invoke arbitration straight away. That's when if the counterparty is being advised by a smart lawyer, would actually object to the notice invoking arbitration, stating that it is premature and not in accordance with the arbitration agreement which has been agreed between the parties, saying that you have to exhaust mediation or conciliation or negotiation, whatever the case may be. You exhaust that first, and thereafter you invoke arbitration. Even if the counterparty does not object to it, the court hearing a Section 11 matter, they invariably look into the provisions of the arbitration agreement, and they say that since the parties have not exhausted the prerequisites to invocation of arbitration, therefore, at this stage, the reference to arbitration would be premature and would be inconsistent with the agreement between the parties. And therefore, the parties are relegated to exhaust that particular remedy which has been agreed upon between the parties. Now, pausing here for a moment, I would like to emphasize that it depends strategically as to which party you are representing. Now, are you representing a party which is keen on invoking arbitration immediately and would not like to go into any further negotiation, conciliation, because it has already spent considerable time in negotiating with the business team of the counterparty? So many a times we come across clients' request where they say that we have been engaging with the business team of the counterparty for, say, last 6 months, but it has not reaped any benefit. There are minutes of meetings where parties agreed to, but they did not honor, or they were unable to reach any form of amicable settlement in spite of multiple rounds of negotiation or discussion. In those cases, if the client comes to us and the client expresses their desire to expedite invocation of arbitration, in those cases, what we advise is that we draft the notice invoking arbitration in such a manner that you overcome the prerequisite of invocation of arbitration. So there, basically, we try to list down the multiple meetings that the parties have had. If necessary, we specify the number of dates. Say, for example, there have been 10 meetings. We list down that meetings on XYZ date. Secondly, if there are minutes of meetings executed, you refer to those minutes of meeting and then conclude saying that in spite of multiple attempts to amicably resolve the disputes and differences, it has not reaped any benefit and the parties are status quo ante prior to the prerequisite of arbitration, that is prior to the negotiation having commenced. And say 6 months or 8 months time have elapsed and no outcome has, like the parties have not been able to reach at any amicable resolution. In those circumstances, parties being referred to further negotiation or discussion would be an empty formality, and therefore, without wasting further time and cost, the party is interested in referring the disputes to arbitration. So in that case, you will possibly be able to rely upon the line of judgments, which where the Supreme Court and the High Courts have also said that when the parties have already relied upon informal channels of discussion to explore the possibility of an amicable resolution, and that has not reaped any benefit, in those cases, again, asking the parties to exhaust the formal process will be a wastage of time and therefore an empty formality. In those cases, it is imperative that parties are referred to arbitration straight away. So that can be done strategically depending on the facts and circumstances. Whereas if you are the counterparty and you are representing a client which is not keen on going into the formal arbitration process as yet, and you want to exhaust some rounds of discussion, you want to sit across the table and try arriving at a midway, then in spite of the parties having failed in their own attempts to amicably resolve, you can always request your lawyer to approach the counterparty's lawyers formally by way of a communication or otherwise to try and facilitate a meeting or a discussion. That is one way of going about it. Secondly, even if a tribunal is constituted, you can also request the arbitrator to act as a conciliator or a mediator. It need not be specified in your arbitration clause that you have to go in for a mediation or a conciliation. So even if contractually it has not been agreed, you can always request the arbitral tribunal to do that on your behalf. And the Arbitration and Conciliation Act empowers the arbitrator to try amicably resolving the dispute. And we have seen it giving very positive results when a retired judge is facilitating or speaking his or her mind in course of the procedural hearing itself, that in my view, these are the points of differences and you should consider discussing in this particular manner. So if the pointers are given to the counsel as also to the parties, uh, and that is natural. Like as lawyers, we also see one more thing is that you talk about mediation, conciliation. It's often considered as a tick in the box when it comes to contractual mediation, conciliation. At least till today, things are obviously going to get better with the Mediation Act being effectively enforced. But as of now, that is how it is perceived. But when it comes to court referred mediation or a conciliation, the parties are very serious. And you see a significant difference in the manner in which lawyers and the parties react when a court is referring a mediation, referring a dispute to mediation or a conciliation. There is much more seriousness, there is much more discipline, and the chances of the matter getting settled also increases manifold. The reason being, at least even if one of the parties is not very keen on going for a mediation or a conciliation and wants to litigate, they don't say no on the face of a judge when the judge is himself or herself referring the parties to give it a try. So even if they are not genuinely interested, they would at least reluctantly give it a try, so as to not antagonize the court on the face of it. So that has been my experience and reading of the situation. When it comes to court referred mediation conciliation, the success rate is much high. Whereas if it is a contractual mediation conciliation, it is often perceived as a tick in the box, and parties are keen on rushing to the formal process of litigation or arbitration, as the case may be. Moving on, qualification of arbitrator and procedure agreed between the parties. That is something, it is discretionary upon the parties as to whether you specify qualification. You come across contracts where parties, say for example, a complex maritime dispute, and the parties have specifically laid down the minimum qualification of the arbitrator, that the arbitrator must be having at least, say, 10 years of experience in like handling maritime contracts or charter party agreements, or like has worked on a in a particular company engaged in the business of shipping, etc. So these are some of the qualifications you can always incorporate, and that is the flexibility again that is provided for an arbitration. You don't get to choose when it comes to litigation. So that's again the subject matter expertise in case of complex issues. Like you will be coming across issues like cryptocurrency, bitcoins, etc. Now, with the changing global scenario, you will come across all these complex topics where you would need subject matter experts and would need basically horses for courses, rather than just having a retired judge adjudicating issues as if it is being adjudicated in a court of law. Then you are not actually exercising or benefiting from the benefits of arbitration to that extent. While I'm conscious of the fact that, like as retired judges of the courts, whether it is a high court or a Supreme Court judge, they would have like a wide range of experience when it comes to adjudicating disputes. But having said that, there are situations where they come across unique circumstances where they are compelled to appoint a amicus or take help of experts, etc. Now, hypothetically, let me give you an example. Say, for example, if you are talking about a state, a judge, a retired judge of a high court, which is landlocked and it is not having admiralty jurisdiction. So, for example, somebody has been a judge only in MP, Chhattisgarh, etc., and all his or her life, and comes across after retirement comes across a maritime dispute. So never exercised admiralty jurisdiction, possibly would not even know what are the important terminologies like a bill of lading, what is a charter party agreement, etc. PNI club, etc. All these which are fundamental to a maritime dispute. So expecting expecting the retired judge, who is now an arbitrator, to adjudicate the matter efficiently and effectively is something which is expecting too much. So it would make more commercial sense for the parties to have an arbitrator who need not be a retired judge, but at the same time has the requisite experience and expertise in the field to be appointed as an arbitrator. Personally speaking, my experience has been that if the tribunal is a mix of technical and like judicial members, it's an ideal tribunal for you because you have the requisite technical expertise flowing from a particular arbitrator, one or two arbitrators, and the judicial member of the tribunal would supplement by giving his or her inputs when it comes to ensuring that the arbitral award or the procedures are followed in a manner which would help in upholding the arbitral award, and it is not amenable to challenge for non-compliance with certain requirements. So therefore, the aspect of composition of arbitral tribunal is important. There are other aspects which I'll come to in the later part when we are discussing about what are the factors one needs to consider while choosing an arbitral tribunal or choosing a sole arbitrator, which is essentially listed out in the penultimate bullet, but I'll come to that in some greater detail later during our discussion today. And last but not the least is a valid notice invoking arbitration under the provisions of Section 21, keeping all these factors in mind. That at least complies with the procedural part of it when it comes to the checklist, if I may say, before you actually consider invoking arbitration, sorry. Now, what does a notice invoking arbitration entail? Now, these are essentially what is the consequence of a notice invoking arbitration in the larger scheme of things. So first and foremost is that it puts the counterparty to notice as to the nature of the claim. So if it is, say, a claim on account of liquidated damages, if it is a claim on account of, say, price variation clause, if it is a claim on account of interest and cost of the arbitration, etc., you basically list down your broad heads of claim. And many a times you also quantify, if not to the last decimal, at least approximately you quantify your claim amount. So that puts the counterparty to notice as to these are the broad heads of claim which I am going to expect in course of the arbitration proceeding. And that would also help formalize and formulate thoughts when it comes to like how to defend. And second is like if you have any counterclaim to lay it out to the claimant from the respondent's perspective. Second is it provides an opportunity for parties to consensually appoint an arbitrator. My experience of this has been that if it is a sole arbitrator, invariably the approach of Indian clients has been that you dispute and deny the name of the arbitrator proposed by the claimant. So if claimant proposes A, the respondent, while may in principle agree to arbitration adjudication by way of arbitration, but would invariably dispute the name A and would propose B because they feel, and there is a reason to it, because in my experience of interacting with variety of clients from across sectors, their approach is that they feel that in India it is perceived that you should have some acquaintance and some form of relation with the arbitrator whom you are proposing to appoint, because they feel that the arbitrator is essentially tacitly going to support you in the arbitration process, which ideally should not be the case because it's supposed to be a neutral, fair, and impartial proceeding. And as I said earlier, that it's substitute to judges of the courts. So therefore, they are expected to act independently and impartially. But the mindset is that if it is arbitration, I have parties feel that we have a chance to possibly manipulate or try to influence or chart the course of the entire arbitration process so as to suit or be convenient so far as you are concerned, which ideally should not be the case and is not the case abroad generally. And that again goes into questionable integrity that goes to the root of the matter, and that is something which should be discouraged in whatever form. Third is allows the opposite party to contest the admissibility of the claims at the threshold and raise counterclaims if any. So as I said, contest the admissibility of the claims can also mean that like if according to you the claims are outside the purview of the arbitration agreement itself, you can always question that. You can, while replying to the notice invoking arbitration, you can place on record your objection. So, for example, if the arbitration clause is a very like constricted one, or it's a very narrow arbitration clause saying that disputes arising out of or in connection with non-payment of service fee under the contract are to be referred to a sole arbitrator, whatever. So, in that case, you see, unlike the earlier arbitration clause I was saying, which was very open-ended and widely worded, here in this case, it is limited to adjudication of disputes surrounding service fee. So now anything over and above service fee, if you are trying to refer to arbitration, the counterparty gets an opportunity to contest the admissibility of the claim, saying that that is outside the scope and purview of the arbitration agreement contained in clause so and so of the contract, and therefore it cannot be referred to arbitration. So you can place on record your objection right at the very outset. So that is one way of looking at it. Secondly, the example which I said earlier, that if it is something which is non-arbitrable on the face of it by as per the laws of India, in those circumstances also you can like raise your objection right at the outset, saying that is something which is not arbitrable under the laws of the country, and therefore that cannot be referred to arbitration. Third is, like if you have a counterclaim, you can lay down the counterclaims in your response to the notice invoking arbitration. And that is something which is extremely critical. I'll discuss it from the point of view when we have discussed the ingredients of notice invoking arbitration and how, as a respondent, you should be thinking or reacting to it, that I'll indicate in a bit. Now, fourth is allows the opposite party to raise the dispute issue of impartiality or bias of the arbitrator. Now, for example, if you are aware that a particular arbitrator is some way connected or is associated with the claimant who is recommending or nominating the person as an arbitrator, in that case also you can raise the issue of impartiality or bias if it is within your knowledge. This is critical because the provisions contained in section 12, 13, etc. Calculates the limitation period of 15 days from the date of knowledge. So therefore, if you have knowledge and if you have not raised that objection, possibly you may have missed the bus. So therefore, if you have any knowledge, you should raise it right at that very moment without waiting for the limitation period under the provisions to expire. And fifth, as we were discussing earlier, that the commencement of arbitration upon the receipt of the notice invoking arbitration, it marks the commencement and the corresponding limitation period for lodging a claim, like substantive claim before the arbitrator, for determining the whether you are referring a valid claim or you are referring a stale claim for adjudication. Third is whether what would be the limitation period in case of a need for filing a Section 11 application for appointment of arbitrator. So therefore, these are some of the like key aspects which one needs to consider after or while issuing the notice invoking arbitration. Now, we have touched upon essentially the requirements under Section 21, but at the same time, some of the important principles I have tried to cull out from some of the recent Bombay and Delhi High Court decisions, which says that the notice should be clear, unambiguous, and reflect the clear intention of the parties to refer a dispute to arbitration. Now, I'll give you an example here. If the parties say that I may refer, see, the disputes and differences have arisen between the parties, and I may refer some or all of the disputes to arbitration in the near future, something like that. So while the notice may be clear, but at the same time, it does not clearly reflect the intention of the parties to refer a dispute to arbitration then and there. In that case, it would be construed to be a vague notice and would not be qualifying as a valid notice for the purposes of commencement of arbitration. Secondly, like until and unless there is a request which has been made by one party to refer the disputes to arbitration, merely setting out the claims or issues would not be enough and cannot be construed to mean that there is a clear intention to refer the parties to arbitration. And the reason why the courts say so is because there are legal consequences and connotations which are associated with the notice invoking arbitration and cannot be considered very casually. It has serious consequences associated with it, and therefore one must be mindful of, and one must be careful while drafting a notice invoking arbitration. That is the conclusion which the courts have taken, essentially. Now, coming to the various ingredients of a notice invoking arbitration. So, first and foremost, the name of both the parties. Like if you are the claimant, either a lawyer is representing you or it's on the claimant's own letterhead that is to be issued with the names of the parties clearly listed out. Address of the parties, again, one may have come across that there is a notice clause generally found in commercial contracts which provides that notice to party A or notice to party B should be at this address and this manner. So one should not bypass that. If you are sending it to other addresses in addition to the one provided for in the notice clause, no difficulty. For example, many a times we send it to the registered office, the corporate office, etc., to multiple addresses to ensure that it is delivered and received by the counterparty in time. But to avoid any technical objections, it is advisable that it is sent to all known addresses, at least where there has been dealings, and through all modes, including email and post, registered post, speed post, or courier, whatever the normal modes of communication that the parties have been following as part of the execution of the contract. Relationship and commercial interactions existing between the parties. Some background about the relationship between the parties is critical to demonstrate the background facts and also lay down how the relationship has, say, I'll give you an example here. Say, for example, if a party has been catering to the counterparty in multiple contracts for, say, 3 decades. So that's an important factor to spell out in the notice invoking arbitration, and also maybe in the statement of claim that you would be drafting at the material stage. So the background relationship and commercial interactions is extremely important to be laid down. And if it is a new transaction, that also can be laid down and has to be carefully worded so as to suit your convenience in the dispute situation, to try subtly create some perception in the mind of the arbitrators about the relationship of the parties. Say, again, I'll give you an example here. Like if the parties have been interacting for long and there was a credit which you continue to extend to the counterparty on the basis of assurances being given that yes, payments will be made, you continue with the work, etc., then this background relationship of 3 decades will come to your rescue to establish that I was acting in good faith because there was past relationship of 3 decades. So therefore, I had no reason to doubt the intent of the party. So that is like one way of looking at it. Similarly, when you are looking at a very fresh relationship between the two parties, say you are dealing with your first project with the party, and there has been a default in non-payment of like invoices, etc., then the reaction will be very different. You may react or stop the work immediately upon the first default and may try to take a very stricter approach. So this background relationship therefore is extremely important. Now, next is facts of the case, which are in relation to the subject matter of the contract. So lay down whatever background in which the contract has been executed by and between the parties, how it has been executed thus far, and where there is a deadlock, and what are the issues pertaining to the dispute in hand. So if once you have laid down that, the responsibilities which were to be performed by either of the parties, like you were to provide site for the other party to deploy men, machinery, and work at your site, etc. So if you have failed in your duty to provide the clear site within a reasonable time frame as agreed under the contract, then the other party is saying or attributing delay onto you for the delay in providing clear access to site. So all those facts are extremely critical, and the notice invoking arbitration should be used to build upon that foundation. Then once you have laid down the responsibilities of the parties and where is the disconnect as to how the relationships went sour and how there has been dispute and difference that has arisen between the parties, that you clearly lay down. And thereafter, then systematically you can come back to the arbitration clause, refer it, and it may be advisable even to quote it in the body of the notice invoking arbitration. Once you have quoted, you can refer to the various ingredients of the arbitration agreement, like we discussed earlier, as to whether there is a need for exhausting a prerequisite to arbitration by way of, say, negotiation, mediation, conciliation, etc. That you can refer to and invite the party for exhausting that remedy. Second is, like, if there is no such prerequisite, you can straight away move on to the qualification, if any, under the arbitration clause, whether it is a sole arbitrator, a three-member tribunal, etc. You nominate or appoint an arbitrator accordingly. If the arbitration clause does not provide for a time frame to respond, then typically, as per Section 11 of the Arbitration and Conciliation Act, it provides for 30 days to the counterparty to respond to that. So that is something which you can stipulate. And what is the actionable which is required to be done by the counterparty? If it is a three-member tribunal, you have nominated A, you have to call upon the counterparty to nominate its arbitrator. So say C is appointed, and once A and C are appointed, then both of them can appoint B, who will be the presiding arbitrator or the umpire. But if it is a sole arbitrator, you will have to say that, say, I am nominating Mr. or Miss X as the arbitrator, and request you to signify your consent to the name Mr. or Miss X as soon as possible, and in any case within a period of 30 days from the date of receipt of this communication. So that is how you clearly spell out as to what is the actionable which is required to be performed by the counterparty, rather than leaving it vague and open-ended, saying that I am nominating or appointing Mr. or Miss X to act as the arbitrator, and just leave it at that. That would not be a clear intention on your part, or to indicate to the counterparty as to what is to be done in the matter. So broadly, this is what we have covered, what we were discussing in the earlier slide, just a ready referencer, and for simplistic understanding of the various ingredients of a notice invoking arbitration. Now, what is important is that one must be mindful of the time when you are issuing the notice invoking arbitration, because there may be repercussions associated with it. Because once you have initiated or commenced arbitration, you may lose out on the opportunity of like amicably resolving the disputes, because you have actually set the arbitration machinery in action, or the timelines have started, the disputes have been raised. I'm not saying that it is not possible, because as I said earlier, that at any stage of the proceeding, even once the tribunal is constituted, you can still approach the arbitrator or the parties directly for amicably resolving it. But at the same time, if the counterparty takes offense to the fact that you have initiated a dispute, then strategically it may not be advisable to issue the notice invoking arbitration. So the timing of the issuance is extremely critical, and would depend upon multiple factors, like how has the relationship been between the parties. Secondly, how has the parties reacted to earlier communications, like whether they have taken a completely hostile approach and you are left with no option but to invoke arbitration and go into the formal dispute resolution process, or whether whether it is there is still a possibility to sit across the table and try to negotiate. In that case, instead of notice invoking arbitration, even your legal advisors can assist you with drafting a soft-toned letter which can evoke a possibility of an amicable discussion, like facilitating a meeting for an amicable discussion before you actually invoke arbitration and get into the formal dispute resolution process. Now, why I say this is that we may talk about like litigation, arbitration, mediation, conciliation, etc. Of course, there are various degrees of like whether it is spoiling your relationship with the counterparty, or like it is actually helping you to substantiate your claim in the formal process. But having said all of that, the best form of dispute resolution is amicable resolution. So there is no better substitute to that when parties negotiate and try to settle themselves without resorting to any form of formal dispute resolution process, whether it is litigation or any form of ADR. There is no substitute to an amicable resolution. So I always say that although it is at a cost of not earning the fee when you are talking from a dispute practitioner standpoint, but at the same time, like if you are able to like negotiate and like with whatever you are able to settle the dispute without actually going into formal modes of dispute resolution channels, then it is actually the parties who actually succeed. Because whether it is arbitration or litigation, it is going to be cost. It is going to cost you time and money. And if you make a cost benefit analysis at the end of a litigation, most of the battles are ego battles. And of course, there are exceptions and genuine commercial matters also. But at the same time, most of it, they can be resolved. It is not that they can't be resolved. Now, you see on the left-hand side, I've mentioned how to respond. Now, this is one side of the story. That is, if you are representing the claimant, that is one way of looking at the entire scenario. There is also a perspective from the respondent side. So you may be on the either side of the table, like you may be representing the claimant or the respondent, as the case may be. Now, if you are the respondent, then also it is extremely critical as to how you react upon receiving a notice invoking arbitration. So that is where the role of the legal experts come in. And if the parties are well advised, if the respondent is well advised, it is always advisable, rather than keeping quiet upon receiving a notice invoking arbitration, saying that like it is his notice, why should I bother? Let him go to the court and have an arbitrator or an arbitral tribunal constituted. But at this juncture, it is important to appreciate the fact that there may be a situation upon you may not, on the face of it, you may feel that there is no counter claim that you may have in the entire process. But upon taking legal advice, maybe you are well advised to have a genuine counterclaim which you have, but you never realize. So that is something which is extremely important for you to set it out right at the outset, the moment you are responding to the notice invoking arbitration. And the if you consider Praveen Enterprises State of Goa judgment by Justice Ravindran, and which has subsequently been followed, the principle of limitation for a counterclaim. This is on this proposition. Justice Deepak Mishra's judgment in Voltas versus Rolta Limited, which follows Praveen Enterprises essentially and reiterates the principle. So there, the principle which was laid down was that how do you compute the limitation period for a counterclaim? Now, for a claim, it is quite clear, as we discussed. Section 21 lays down the timelines the moment notice has been served on the respondent. But from the respondent's perspective, what would be the limitation period for a counterclaim? So the answer to the question is, like, if you have effectively responded to a notice invoking arbitration by laying down your own counterclaims as if you are setting out the claim yourself. So essentially, you are transposing yourself or stepping into the shoes of the claimant, and you are raising your counterclaims in your response to the notice invoking arbitration as if you are the claimant, and laying down clearly that A, B, C, D, these are the various heads of counterclaim that I have. And this is the quantification, approximately the quantification of my counterclaims. Then that notice, receipt of that notice from the respondent and by the claimant would be construed as the date for the purposes of limitation of counterclaim, would be considered as the date of receipt by the claimant. So the day on which the respondent's response to the notice invoking arbitration, laying down the counterclaims, is received by the claimant, that would effectively be the date for the purposes of the limitation of counterclaim, the date of receipt of that communication. So therefore, it is critical that when you are responding to the notice invoking arbitration, it should not be vague. Rather, the same principles which we discussed about the ingredients of notice invoking arbitration should also be followed while you are responding to it. But in case you do not have any counterclaims, then of course it can be a very basic formal letter, uh, uh, like dealing with the contents of the notice invoking arbitration, either like responding to it in detail, and giving, say, parawise response and why you are denying the name of the arbitrator proposed, or alternatively, it can be a very short, crisp letter saying that I reserve my right to deal with the contents, and I am not my denial should not be construed as admission of any of the contents of the allegations contained in your notice invoking arbitration, and I reserve my right to deal with and respond to the same at the appropriate stage in the arbitration proceeding. So that is another way of doing it. Even for a notice invoking arbitration, while keeping the ingredients intact, it can be a detailed letter in the form of a notice wherein you spell out all the entire background to the dispute, what the parties were required to do, and how it has culminated into a dispute. There are other kinds of notices also where they briefly talk about date of contract, the nature of dispute briefly, and then a broad quantification or approximation of the claim. Now, there are some of the judgments which I have listed down. It's essentially lays down some fundamental principles, some of which we may have already discussed. Like 2022 Florentine judgment of the Delhi High Court, it says that notice invoking arbitration under 21 is mandatory. Without that, you cannot set into motion the arbitration machinery. Second is like Malvika Mehta versus Jess Corporation, again a Bombay High Court 2022 decision, which says that issuance of the notice can be opted out by the parties to this dispute by agreement. Again, the phrase unless otherwise agreed by the parties, that comes to action. That if the parties have agreed to opt out, that there will be no need for issuing a notice invoking arbitration for the purposes of 21, then that would suffice. Like that agreement would prevail, and then the mandatory nature of Section 21 cannot be insisted upon. Again, Alupro reiterates the same thing, is a condition precedent for seeking the appointment of an arbitrator. This is one important judgment of the Delhi High Court, Ministry of Youth Affairs and Sports versus Agility Logistics. Here the court says that the notice invoking arbitration need not quantify the exact claimed amounts, but should set out the dispute. So as I indicated that it need not specify till the last decimal as to what is your claim amount. It is advisable to broadly capture, or at least in approximation, you capture what is your claim amount, but it may be a situation where the concerned commercial team or the business team of the client may not have actually quantified the exact claim amounts at that stage when you are instructed to issue the notice invoking arbitration. And at that stage, it is okay for you to just give a broad approximation, or like maybe just set out the dispute heads, and rather than specifying any claim amount to each of the heads. Sundaram Finance versus NEPC, while the judgment is more in the context of the court having jurisdiction for the purposes of Section 9, but at the same time, why it is also important is that as a matter of practice, when we are filing Section 9 application before the court, we usually advise clients that it is to demonstrate that the parties genuinely intend to refer the disputes to arbitration and not invoking Section 9 jurisdiction just for the sake of getting interim reliefs and forgetting about the arbitration, which used to be the practice earlier. We advise the client to at least issue the notice invoking arbitration and enclose the same as an annexure to the Section 9 petition, so that there is clear discernible intention on the part of your client, which can be demonstrated from the document itself. And you don't have to give any explanation in the form of pleadings in the Section 9 that, yes, I am in the process of initiating, invoking arbitration, or there is clear intention to refer disputes to arbitration, etc. So that notice invoking arbitration, there cannot be a better evidence than that. So it is advisable to do so if you are asking for any interim reliefs before the constitution of the arbitral tribunal. About the limitation period, we have already spoken about that the commencement of arbitration, the period of limitation runs from from the date the notice invoking arbitration is served, and the Supreme Court in both these judgments, Panchu Gopal Bose and Budhraja, in both the judgments, the Supreme Court has tried to draw an analogy between a civil suit, how a limitation period is computed, and the commencement of arbitration. So the court has tried to equate the two and tried to conclude, which is essentially the gist of Section 21, that for the purposes of a claim in an arbitration is to be calculated on the date on which the arbitration is deemed to have commenced. So therefore, the date of the notice invoking arbitration having been served is extremely important for the purposes of computation of limitation in arbitration proceeding. The next two judgments I just briefly talked about, will not repeat it here. So for the purposes of counterclaim, limitation will be computed on the date of its institution before the arbitral tribunal, unless the response to the notice invoking arbitration itself is broad enough and has covered or raised all the counterclaims and referred it for the arbitration while replying to the notice invoking arbitration. So to put it simply, you receive a notice invoking arbitration from the claimant. As the respondent, you assess whether you have counterclaims. If you do have counterclaims arising out of the same contract, it is advisable for you to respond to the notice invoking arbitration with the same details as if you would have invoked arbitration. Lay down your counterclaims, quantify it, and send it as your response to the notice invoking arbitration. In that case, your limitation for counterclaim would stop on the date when the claimant receives that notice. If you don't do that, then your limitation will continue and will stop only when you formally file your counterclaim along with your statement of defense in the arbitration proceeding. In matters where your counterclaim is borderline limitation period, then in that case you may lose out on a few months, and you may, for all you know, your counterclaim may be time barred as well. In case the claimant delays filing of claim, statement of claim, and you wait for your opportunity to file your counterclaim and your statement of defense, that may come, say, after 5 months or 6 months from the date of constitution of the arbitral tribunal, depending on the matter. So that 5 and 6 months that you save by issuing a comprehensive response to the notice invoking arbitration and referring your counterclaims also for the same arbitration, it may be saving you on the limitation period. Moving on, we spoke about party autonomy being sacrosanct, and it provides you the much needed flexibility to choose a private judge to adjudicate all your rights and obligations and like basically determine your claims. There are multiple factors for you to consider while nominating or proposing the name of an arbitrator to act as the arbitrator adjudicating your disputes. Now, there is, you hear any conference or seminar on arbitration, you will generally see that institutional arbitration is the way to go. I have slightly a different take on this. I feel that it has to be dependent on the nature of the dispute, the quantification of the dispute, and it cannot be that each and every dispute should be referred to institutional arbitration. Because while institutional arbitration is extremely efficient and is the way to go, no doubt about that. But at the same time, for small ticket matters, like if the stakes are low, in those cases, ad hoc arbitration may be providing you much needed flexibility and provide you much needed commercial viability. Whereas institutional arbitration may essentially make you feel that I may have succeeded in the arbitration, but effectively I spent a lot of money, which did not make the entire exercise commercially viable for me as a litigant. So therefore, for say, if it is a 2 crore or a 5 crore arbitration, it may not make commercial sense for you to go into institutions. Rather, a sole arbitrator, either appointed mutually or if not by way of the court's process, that would be more meaningful and relevant. Of course, you have the other institutions which are like associated with courts, like the Delhi International Arbitration Center, etc., which is extremely reasonable and provides you like state-of-the-art infrastructure, etc., where possibly even for small ticket matters, and I have personally done MSME matters which are very low stake also through the institution of DIAC. There it may make sense. Here, institutional, I'm referring to the international institutions, say like ICC, SIAC, etc. In those cases, the small matters, it may not make sense to go in for those institutional arbitration in those kinds of matters. So therefore, when you are drafting the contract, when your corporate teams or the commercial teams are drafting the contracts, it's extremely important to anticipate what would be possible nature of dispute, what would be the nature of claims, and keeping that in mind, one must formulate or draft the arbitration clause rather than lifting it as a cut copy paste exercise or a boilerplate clause. It should not be treated as such. Rather, some application of mind, and in fact, some serious application of mind is required. And these days, we see a lot of our corporate team colleagues reaching out to us as dispute resolution lawyers to vet the clause, the dispute resolution clause, the jurisdiction clause, etc., because those may have serious implications and ramifications in a dispute scenario. So where should be the seat? Where should be the like whether it should be an institutional or a ad hoc arbitration, whether it should be whether it is in domestic or an international arbitration, whether there is a need for specifying the minimum qualification of arbitrator, etc. All these factors needs to be carefully considered and while drafting an arbitration clause or a jurisdiction clause. Similarly, the relevant contractual considerations could be whether it would be a sole or a three-member tribunal. Again, giving an example, if you see the entire value of the contract is say 50 lakh, you are incorporating an arbitration clause. If you are just lifting a dispute resolution clause from another contract, and you are finding that it provides for a three-member arbitral tribunal, say with a minimum qualification of, say, being a chief justice of a high court, retired chief justice of a high court as the minimum qualification. Now you end up for a say for a 50 lakh contract, the maximum a dispute would be around in the same range. So hypothetically, if it is for a 50 lakh arbitration, you are having a retired chief justice of a high court and three of them as your arbitrator. You can imagine that it's criminal waste of time of the tribunal, which could have been easily adjudicated by, say, a senior advocate or a lawyer or a retired district judge. So in those cases, specifying the minimum qualification or providing for a three-member tribunal makes the entire process commercially unviable. So these are some of the considerations one needs to have while determining how the arbitration clause is to be worded. Now, in international commercial arbitration, if the one party is from, say, UK, if the other party is from India, and you are basically having an arbitration clause where you want to ensure neutrality. More often than not, the parties agree to a third nationality to demonstrate some form of neutrality. You may say that should be if the arbitral tribunal should comprise of members who are not of nationality UK or that of India, so as to bring in some form of independence or impartiality or some neutrality to it. So while it actually achieves the objective or not is another story, but at the same time, at least on paper, on record, you can demonstrate that neutrality incorporated. Similarly, if we are talking about a domestic arbitration scenario, one party is from Delhi, one party is from, say, Chennai. You want to demonstrate some neutrality and don't want to give undue advantage to either of the parties. The flexibility of arbitration is that you can have a completely neutral seat of arbitration, and you can agree to say Calcutta or Mumbai as your seat of arbitration. So this flexibility you would not get in a litigation scenario, because section 20 of the CPC would kick in, and there has to be some connection or privity with the cause of action for you to establish territorial jurisdiction. Whereas for arbitration, that requirement is not there. In other words, for example, party from Delhi and party from Mumbai, party from Chennai, they will be at liberty to agree on a Mumbai seated arbitration or a Calcutta seated arbitration. And the moment you designate the seat or agree on the seat, as you know, the entire supervisory jurisdiction on the arbitral tribunal is conferred on the particular location or the jurisdiction. So these are some of the relevant considerations one can have while formulating or drafting an arbitration clause. And like while appointing an arbitrator, as I was indicating, that if the parties have not agreed to a shorter timeline, the statute, that is section 11, provides for a 30-day period for the counterparty to respond. So in the first scenario, if you see the first tab, it says that response, you issue a notice invoking arbitration. The counterparty, that is the respondent, responds within the 30-day period, and he or she consents to the person you have nominated. Then automatically there is a consensual appointment which takes place. So Mr. or Miss X, whosoever has been agreed to by and between the parties, gets appointed as the arbitrator and enters into the reference. So no problems there, no dispute there. That's an ideal case scenario, which typically does not happen, at least in a sole arbitrator case. Second, response to the notice invoking arbitration received within the 30-day period, disagreeing on the nomination with alternate names. So it may be a situation where Mr. or Miss X name has been proposed by party A. Party B responds to the notice within 30 days, but says that no, it would not be Mr. or Miss X, rather it would be Z. So now you as the claimant, like if party A agrees to the alternate name Z, then the confirmation of appointment happens, and then Mr. or Ms. Z by consent gets appointed as the arbitrator. But if there is no consent and party A disputes the name Z and proposes say Y, then of course there is a disagreement between the parties as to the name of the arbitrator, and consequently it gives a cause of action for appointment of arbitrator through court under section 11. Either party can approach the court. Now, third situation is response to the notice invoking arbitration is received, but there is disagreement on the nomination without any alternate names or no response received. So there can be one situation where the party responds, the respondent responds, but does not provide for uh, any alternate names like Z or Y or whatever. Just remain silent, simply
Uh, so, can you hear us? Can you hear me? I guess there's some network issue, guys. Just wait for a few minutes.
am I audible?
Yes, sir, yes, you're audible.
Yeah. Yeah. So if there is a disagreement with the nomination without any alternate names proposed, or if the respondent just remains silent after receiving the notice invoking arbitration, in those cases also there is a cause of action for approaching the section 11 court. In case of a three-member tribunal, there can be two scenarios. One is when the response is received within 30 days, appointing the party's nominee, respective nominees, and two nominees, say X and Z are nominees and they agree to Y as the presiding arbitrator, there is no difficulty. And usually there is no disagreement when it comes to a three-member tribunal. But there are also situations where both parties have nominated X and Y, but X and Y, the two arbitrators, are unable to agree on a third arbitrator to act as the presiding arbitrator. So in that case, also one can go to the court for appointing the presiding arbitrator only. So that is also a possibility. Now, like with over a period of time, the scope of interference by the court under Section 11 has been reduced to a lot extent. And now what the courts they see is the existence of an arbitration agreement and existence of arbitrable disputes. So one is a valid arbitration agreement, whether it exists between the parties. And second is the existence of arbitrable disputes in the sense whether it is a dead or a stale claim, or whether it is an arbitrable dispute at the first place and does not fall within any aspect which is non-arbitrable at the first place. So these are aspects, the limited aspects which the Section 11 court considers while adjudicating an application for appointment of arbitrator. This judgment is critical by Justice Indu Malhotra. It is this for the first time talked about what is the limitation period when it comes to filing of an application under Section 11. The Arbitration and Conciliation Act is silent, and the court came down heavily, saying that it is important for the legislature to lay down timelines and strict timelines. It should not be that the court has had to, as in this particular case, the court had to fall back on the residuary clause of the Limitation Act to say that by default it is 3 years for appointment of arbitrator through court. The court said that when we are talking about effective arbitration, it cannot be 3 years just for an application for appointment of arbitrator. Stricter timelines are to be introduced by the legislature. Moving further. So I'm conscious of the fact that we have about 25 minutes. So Akarshvi, should we just open it for questions? I see some of the participants raising hands.
Yes, yes.
I can
Whoever is
share it
having
also.
question, please raise your hand. I'll unmute you guys. Please go one by one. Yes, Mihir.
Hello.
Yes, Mihir.
Yeah. Good evening, ma'am. I haven't raised the hand. There is no option. So
So you don't have any question?
no, not right now.
Okay, okay, no problem. I'll lower your hand. Yes, Vaishali, you can go next.
Good evening, ma'am.
Good evening.
Good evening.
Mihir, please mute yourself.
Hello.
Yes, Vaishali, I guess
Yeah,
expert is
yeah.
a little bit
Good
occupied.
evening, sir. Ma'am, I have three questions. One was actually answered by sir just now. But two questions now. Please elaborate on practical procedure of witness action. This was really introduced in the beginning intro when the slide was not started. When we were talking about virtual arbitration, when people were pushing virtual arbitration and then they were pushing for physical arbitration, means the topic of how clients suffer. Sir talked about witness action. What is witness action? Please elaborate.
So thank you, ma'am, for your questions. So far as I'll just carve out a distinction between institutional and ad hoc arbitration. Now, coming first to the ad hoc arbitration, generally it is dependent on what parties agree. If the parties are able to agree on the procedure, then that would follow, and that is essentially stipulated or like incorporated in the procedural order by the arbitral tribunal. That is usually done in the very first hearing, and parties' consent is obtained, and both the parties they indicate to the tribunal that this is the procedure which we would like to follow. The council make appropriate submissions in that regard, and that is what is incorporated in the procedural order.
Okay, sir.
Now, once that is done, then the arbitral tribunal and also the parties are bound by it, unless by consent again they are modifying that procedure to some extent. Like, say, for example, pre-COVID, some procedure was agreed which had to be altered because of the lockdown, for example. So, in those circumstances, of course, the parties are at liberty to agree. And again, coming back to the point, party autonomy is sacrosanct. So, therefore, nothing stops the parties as long as there is agreement between them. And the arbitral tribunal is only to facilitate or carry out such agreement which is procedurally agreed. Now, many a times it happens that the parties are unable to agree on the procedure. In those circumstances, the arbitrator is empowered to frame the procedure and lay down on its own by under the provisions of, say, Section 19, while the CPC, Evidence Act, etc., doesn't apply, but at the same time, the principles do apply. So therefore, you more often than not, the arbitrators, they follow the procedure which is done in a simple
They follow the
manner.
guidelines actually more
That's
than law.
correct.
They follow the guidelines.
That's correct. So the principles of CPC, the principles of Evidence Act, those are followed and those are laid down in the form of a procedural order. So that is one way of doing it, insofar as ad hoc arbitration is concerned. Secondly, insofar as institutional arbitration is concerned, most of the reputed institutions, they had their own guidelines. They do come up with their own guidelines as to how an evidence is to be conducted, like whether it is an expert witness or like it is a party's witness, and what is the time frame to be given to each witness, whether it is going to be a chess clock mechanism and cannot be a perpetual cross-examination, whether it is a questionnaire which is submitted for discovery, production, etc. So it would essentially depend upon the institution's own procedures, or alternatively, that can be modified to some extent by the arbitrator in consultation with the parties. So that is how normally it is done.
Okay, sir. Thank you. So one more question.
Yes, please.
That was how to file for invoking arbitration in court. That is section 11, but that is statutory arbitration. But what we go for is like filing for statutory under section 11, file for application. But the backend की मतलब ये institutional arbitration has been done or ad hoc or mediation has been done or other ADR resolution. Uh, Nobody actually thinks of incorporating this in the application. Means when I have seen being drafted, I've never drafted it. So is it important that in the application we file a memo of the dates, references, like we have done mediation, conciliation, or and then we have gone to arbitration, all have been unsettled mediation, negotiation, uh, so that there is a weightage to the court that now we are resorting to statutory arbitration and that court shall provide, and no, means in that's not the application for dismissal. I am talking through about a client that court should provide weightage to this application.
So one can, like, of course, if you have exhausted substantial time and spent substantial time on like all these informal modes like conciliation, mediation, etc.,
Yeah.
depending on whether it is a prerequisite as per the arbitration agreement or not, you must specify. Irrespective of that, it must be specified in the Section 11 application, so as to give an indication to the court that we have exhausted all remedies and now it is imperative that you constitute the arbitral tribunal without any further delay. So that is something which is extremely important. Secondly, if you have agreed for a prerequisite and you have not exhausted, if I am the respondent and I'm intending to delay the arbitration process, I would seek leave to file an objection or a counter affidavit to your Section 11 and would say that the prerequisite has not been exhausted, and therefore this application under Section 11 is premature, the invocation is premature, therefore parties should be referred to arbitration first. Parties should be referred to that prerequisite to be
Okay.
exhausted first. So that way I'll be successful in derailing the arbitration process. So therefore it is important.
Okay.
Yeah.
Sir, and my last question is how to set out claim amount in notice though Ministry of Youth Affairs judgment which you mentioned clearly stated that we may not specify exact amount, but the client say that we have incurred this month 16 या 20 lakhs का we have got that इतना damage हो गया है. Now I want a new project या फिर I need to stop the project so that
So,
I want the computation of damages incurred, cost and quantum of claim amount, because in a notice like answering to the client like you can claim this much sir, and specifying in a notice that how to do that means computation.
So for example, if in a project the clients have already computed a certain sum and they are not they have not completed that exercise, and there is a possibility of them coming out with a higher number later, you should leave the figures open-ended. You say that at least as on as quantified, the amount stands at X. However, I reserve my right to alter this figure at the time of filing the statement of claim after like getting better details or like finding more
Yeah, because
particulars
they're
on that.
like you have specified this amount and then I want to raise the amount because I had incurred more. The same, that was my thinking key how to.
Yes.
Okay. Okay. Thank you so
Thank
much.
you.
Sneha, you go next. Okay, Sunil, you go.
I think there are some questions on the chat box. I can take them.
Yes, in the Q&A
Am I
section.
Q&A
audible?
section. Yeah. Yes, you are.
Good evening, sir.
Hello, good evening.
Sir, my question is, first of all, I'm a bit confused. When a person who invokes arbitration proceedings or who files Section 11, first of all, I want to know where, in which forum or in which court the Section 11 petition has been filed. Is it a district court or a high court? And I also wanted to know, I'm a bit confused that there is a sole arbitrator and there are many cases there are 3 members arbitral panel. Just like as you have explained that in 3 members arbitral panels, the parties to the agreement uh, mutually agrees to the arbitrator, and the both the arbitrator then they decide the third arbitrator. I wanted to know, is it also the remedies also before the high court that they can decide the arbitrator of their own choice, or is it the parties to the agreement who can decide the arbitrators?
So, with respect to your first question, there was a recent Supreme Court judgment. I'm forgetting the name. It was which said that now it is to be adjudicated. The Section 11 applications are to be decided by the court as defined under the Arbitration and Conciliation Act. So, even the district courts now can decide where there is no ordinary original civil jurisdiction, like the chartered high courts. Delhi, Bombay, Calcutta, and Madras are the chartered high courts. So, other than that, if it is before any other, for example, if it is Orissa High Court, then instead of the High Court, now court will mean the district court, where which will qualify as the definition of court for the purposes of domestic arbitration. So for appointment of arbitrator, you can go there. That for other courts like these 4 chartered high courts, you can also approach the respective high courts because they exercise original jurisdiction. Now, secondly, in terms of international commercial arbitration, which can mean like the moment there is one of the parties is a like foreign player outside India, residing outside India. In those cases, it is the Supreme Court which has the jurisdiction and not the High Court or the District Court. So that is the answer to the first question. Second, with respect to your second question, it is the parties who nominate the arbitrators in a three-member tribunal. So to put it into perspective, Party A and Party B, Party A issues the notice invoking arbitration, nominating X to act as its nominee arbitrator. Then Party B will nominate, say, Y as its nominee arbitrator. X and Y are the nominee arbitrators for A and B now. Now X and Y will appoint a presiding arbitrator, say Z, who will act as the presiding arbitrator. So X, Y, and Z in total constitutes the three-member arbitral tribunal. At any stage, if there is a disagreement or one party is not acting, then it gives the cause of action to the counterparty to approach the court under Section 11 for appointing that particular arbitrator. In some cases, we also, in a three-member arbitral tribunal, request the court in a Section 11 proceeding that it is not going to be commercially viable to have a three-member tribunal. The parties are in agreement. You please appoint a sole arbitrator, even though the contract provides for a three-member tribunal. So it can be done at the Section 11 stage by recording the consent of the parties also.
Okay. Sir, I also wanted to know, so while if somebody is agreed by the arbitral award, at what forum he or she or the one can challenge the arbitral award?
So for that, again, Section 34 would apply for a domestic arbitral award or an India-seated arbitral award. For that, you will have to file it before the court as defined under Section 2 of the Arbitration and Conciliation Act. And it would all be governed what is the seat of arbitration, which court has the supervisory jurisdiction over the arbitral tribunal. So, for example, if you have agreed to New Delhi as the seat of arbitration, then the New Delhi courts, depending on the pecuniary jurisdiction, would have the territorial jurisdiction or supervisory jurisdiction over the arbitral tribunal, and you will have to file the challenge there under 34.
Okay, fine, sir. Thank you, sir. Great.
Thank you.
Great.
Sir,
Yes, sir.
I am audible. I am
Yes, you
audible.
are. Yes, you are.
Sir, what is to practice as an arbitrator? So only for law qualification is any other additional qualification to be acquired for that practicing as an arbitrator?
So various institutions, they have the requisite qualification. It need not necessarily be that for being empaneled as an arbitrator, you have to be a lawyer. Various arbitral institutions, for example, India International Arbitration Center, where I'm associated with, or Indian Council of Arbitration. If you go to their website and go to their application for appointment as arbitrator, empanelment as arbitrators, they provide even engineers or chartered accountants or various other qualifications also on a particular area of expertise. You can have yourself empaneled as an arbitrator. So being a judge or being a law graduate is not mandatory. So each institution have their own panel, and depending on your expertise, they will assign you matters.
Sir, I heard that there is a 40 hours training or compulsory for the arbitrator and mediation for that. What I heard for that. That's why I'm asking you in details.
No, every institution, sir, has different prerequisite qualification. For example, if as far as I recollect, DIAC, Delhi International Arbitration Center, requires, I think, 10 or 15 years of practice as a lawyer for you to apply as an arbitrator. So at least be eligible for being an arbitrator. Similarly, some other institution require at least 10 years of service or 15 years of service. And the form is quite exhaustive usually, and they need to see how you demonstrate your experience or expertise in arbitration. So some of the factors, like you may refer to their respective qualification requirement, it varies from institution to institution.
I need not go undergo any training for that or passing out any
It's
examination.
always better, like if you have, as I said, the details, the columns are quite exhaustive, like they require publications, etc. So the more you can demonstrate your association with arbitration, it is easier for you to get your application passed. So it's better to upskill yourself with like whatever courses but I don't think it is mandatory. They won't specify that this, some of them may be, some of the institutions may specify, but generally, as far as I am aware, at least the institutions, they did not insist on.
Okay, sir. Okay, thank you.
Thank you, sir.
Hello. Hello.
Yes, sir.
Yeah, good evening, sir. So my
Hello.
question was regarding this jurisdictional issue I've been facing recently. मतलब कि in one of my case, sir, it was like, sir, the broad issue is which act between Commercial Courts Act and Arbitration and Conciliation Act would reign over the other. So because the issue which I've been facing was, sir, like Commercial Courts Act 12 says I can't issue a proceeding unless I exhaust the arbitration clause. Sir, so if I want to file a complaint under, let's say, in section 9 or 14, who, like, in whose court should I file that complaint? In the DJ's court or in the commercial's court? The designated commercial's court. So because the Arbitration and Conciliation Act says no judge other than the executive level, and sir, the Commercial Court Act says the designated commercial court shall take such a dispute. So in front of whom should I file that complaint?
So far as Section 12A is concerned, that is applicable in case of a commercial suit. So the
Yes, sir. Yes, sir. Yes, sir.
So pre-institution mediation is something which is mandatory under Section 12A before your plaint is registered and a suit is lodged. So that is independent of any arbitration proceeding. So if you file a commercial suit, then you will have to mandatorily overcome Section 12A. To avoid Section 12A requirement of mandatory mediation, what parties do is they file an interlocutory application under Order 39, Rule 1 and 2 to say that there is extreme urgency in the matter and therefore mediation would make the relief of interim injunction redundant. So many a times it is incorrect urgency is demonstrated. And in some other cases, like parties are relegated to mediation before the suit is actually instituted. So that is something which is to be filed before the commercial court, as per the Commercial Courts Act. So far as arbitration applications are concerned, whether it is a Section 9 or any interim application, that has to go as per the definition of court under the Arbitration and Conciliation Act. And court as defined under the Arbitration and Conciliation Act, and which typically, like if it is a non-chartered high court jurisdiction, like if it is, say, Haryana or something, like if it is Haryana, then automatically it will go to the district court having jurisdiction,
Sir,
depending on the
MP.
pecuniary limited. No, irrespective, like I'm just giving a hypothetical example. So it would go to the commercial court, which exercises jurisdiction in arbitration matters.
Okay, sir.
So that is independent of Section 12A. 12A has got no application so far as arbitration proceedings are concerned, because by virtue of Section 8 of the Arbitration and Conciliation Act, a suit is barred the moment you have an arbitration clause.
Okay, thank you, sir.
Hello.
Hi, Jeevan.
Yes.
This is Vivek.
Yes, sir.
I have this question that, while discussing the arbitration clause in the agreement, you said that it should be specifically drafted. But if you see one of the even SIAC or other forums clauses, they are pretty widely drafted. So, how to make changes in the agreement or in the clauses if we want to be making it very specifically drafted?
So insofar as institutional arbitration are concerned, sir, the request for arbitration is a detailed form which is prescribed. Like there is a form, like for example, if you see ICC, their website provides and also their rules provide for a particular format which is to be followed for invoking arbitration, the request for arbitration, basically, which is called. But in that case, you need not strictly follow the Section 21 requirements because you have submitted yourself to the institutional rules for the purposes of like adjudication of your disputes by way of arbitration. So the institutional rules will govern the procedure there. But if it is an ad hoc arbitration, the Section 21 requirements which we discussed today, those will be relevant. But what I'm trying to draw analogy from is that the request for arbitration under any institutional rules or Section 21 and for in case of an ad hoc arbitration also, the broad ingredients are more or less the same. And the structure which we discussed about the name of parties, that these ingredients you will invariably find also in the institutional arbitration. And the narration would be also quite common. It's just the form, but the substance is more or less the same.
Okay. Okay. Thank you so much.
Thank you.
Hello, sir.
Hello.
Sir, this is Sunil. I want to know if in the clause of the arbitration, if I want to mention that sole arbitrator appointed by the party 1 or 2, that can be done, or either I have to mention that it is unanimously appointed by the both parties like that.
Sir, after the Central Organization for Railway Electrification judgment of the Supreme Court, the Constitution Bench recent judgment, unilateral arbitrations, they have been completely done away with. So if you have such a clause where one party has the right to appoint the arbitrator, then that would not stand the test of the court judgment. So therefore, that will be set aside and the other party can always approach the court for appointing an independent arbitrator. Earlier,
So
that used to happen particularly for PSU arbitration clauses, but that has been done.
If some clause is there, so that I can at the time of initiating the arbitration, invoking the arbitration, I can mention that we are appointing so and so person as an arbitrator. Like that, I can mention and send the notice.
So you can always send the notice saying that, but it is unless the other party consents, that arbitration clause will not be valid, and it is always, even if you had a clause earlier, like say for example 5 years back you had drafted a clause which provided for that, and the dispute you are having is culminated today. So it is better, even if that provides or gives you the right to appoint an arbitrator, it is advisable to have a independent arbitrator proposed rather than you only deciding it. You ask for consent from the other party. Otherwise, at a later stage, the award is not going to be a valid award and can be challenged on that ground itself.
Okay, sir. Thank you.
Hello.
Yes, sir. Please go ahead, sir.
Sir, actually, mine is very big doubt, sir. I sent mail to madam, mail doubt regarding that limitation period, sir.
Okay. Sure, sir. You can connect with me on LinkedIn offline also. If there is any question, I can help you.
Yeah, please share your LinkedIn, sir, please, sir.
I'll share the LinkedIn profile.
Yes. Actually, madam.
Yes.
Hello, madam.
Yes, yes.
Actually, instead of sir, I sent to you the mail.
No problem.
Okay. Doubt regarding the limitation period, sir.
Anyone else? Akashvi, I have sent the PPT on.
Yes, I'm just sharing it over here.
The PDF of that I've shared.
Yes, thank you, sir.
Any other questions or?
Anyone? Do you have any question?
Hello, ma'am.
Yes.
Vaishali here. Ma'am, the PDF, it's not showing in chat. Could you please share it again?
Which PDF? I haven't shared any PDF yet. I'll be sharing a PDF.
Some link was given.
Yes,
Oh,
that's
I
the link
think
in
I
the
have
chat.
filled the form 2-3 times.
No problem.
Okay. Ma'am, one more question when I have you. How can I access this guest lecture video?
You will find this on your LMS portal.
LMS portal. Thank you, ma'am.
Welcome. So I guess there's no other queries. If you have any queries, please raise your hand. If you guys don't have any queries, I think we should end the session because we cannot make our guest waiting.
Thank you, ma'am. Just waiting for the PDFs, PPTs are shared with you.
Yes, I'm just sharing.
Thank you, sir. Have a good evening.
Thank you. Thank you everyone for joining in.
Thank you so much, sir.
Thank you. Bye.
Thank you, sir.
Thank you. So guests are left. Okay, I'll share the PPTs here as well and over the mail as well. The mail I received, I'll share that over there.